So we're going to go over Chapter 2 of the Dearborn, New Jersey Real Estate Principles book. So here's what Chapter 2 is going to discuss. Chapter 2 is going to build right off Chapter 1, where in Chapter 1, we identified who needs a license, who regulates the real estate licenses, which is the New Jersey Real Estate Commission, which is the Department of the New Jersey Department of Banking and Insurance. We discussed if you are working in the real estate industry without a license, what can you do, what can you not do? We identified the different types of licenses and the requirements to obtain those. In this chapter, we're going to kind of assume that you've identified, hey, I need a real estate license to do what I intend to do. Now that you have gone through the requirements as to how to obtain the license, you're probably now going to be asking yourself, so what are some of the rules and regulations about, initially setting up business? What are the rules and regulations for a broker who wants to open up a business in the state of New Jersey? What is the rules and regulations for people under him? All that kind of stuff. So let's talk first about some of the limitations that are on a salesperson or a broker salesperson. So anyone working under the supervision of what we would identify as a broker of record, okay? So first and foremost, and I want to really make this clear, you cannot accept any form of compensation except from his or her supervising broker. You cannot directly be paid by a homeowner, by a builder, by anyone. You cannot do that. It has to go through your broker. Now, they'll try to trick you with some questions on the test because here's the thing, this is the big one here. It says any form of compensation, okay, must go through your broker. Your broker must be the one to hand it to you. They must be the one to give that to you. Now, you will have an agreement with your broker in regards to how you are going to get paid, because that is something that they are required to do, okay? So what will happen is, based on that agreement, is how you will get compensated, even if the form of compensation is something other than monetary. So if there is a bonus of, a Ferrari for selling a home, crazy as it might sound, there have been some things not exactly like that, but things like that is forms of compensation, totally legal, okay? But that has to pass through your broker. So what happens is the broker would come in possession of the car, and then they would give it to you, or they would come in possession of it and not give it to you, not relinquish it to you because of your employment agreement. You might agree with it, you might not. But again, your employment agreement is really going to be what dictates how they handle things like that. And that should be outlined, okay? A salesperson or a broker salesperson may not maintain an escrow account or hold funds belonging to others. So let's talk about when they say escrow account. We're going to go into this in detail in this chapter. An escrow account is also referred to as a trust account. This is a non-interest bearing account where you have clients' money in that account, that only clients' money goes in, clients' money goes out. It does not go for operating expenses, anything of that nature. So that is something that we will talk about. Only the broker of record can have an escrow or trust account, and the ledger must be kept at the office, and it has to be very detailed, and it has to show money in, money out, and that there is no commingling. You'll hear that word over and over again. Commingling is the mixing of operating funds with that of funds from clients. So you cannot do that. That is an illegal practice, commingling. The other thing that you cannot do as a broker salesperson or a salesperson is you cannot work for two or more brokers, okay, in the state of New Jersey. Now, you can work for more than one broker in different states, and that's why they specify this. They go, you cannot work for more than one broker in New Jersey at one time. But there are other states that allow for this to happen. So New York is a famous example, because there are people, because the state is vastly geographically larger. So if someone has two different residences, like I know a lot of people do the Hamptons and then something else in the wintertime. So what happens is this: they might work in two completely different markets. And they could hold dual licenses. In New Jersey, that is illegal. You cannot work for more than one broker at a time. Now, let's talk a little bit about place of business. So there's going to be things that they're going to refer to as a main office. Excuse me, I got a little hiccup there. Main office and a branch office. So let's talk about this. Main office is going to be something that is identified as that corporation's, that broker's main branch of business. So, okay, let's talk about Weichert Realtors, big agency out in New Jersey. Weichert Realtors has their corporate headquarters in Morris Plains, New Jersey. Morris Plains, New Jersey. That is their main office, a huge campus up there. Have is considered a branch office. So a couple things about the main office and the branch office. So every single office has to have on the front door, broker of record, Jim Weichert. That would be for Weichert Realtors. So you need to have the broker of record. Who is the broker of record, the designated broker? Their name has to be on the front door of every single main office and branch office, regardless of who might be running it. Now, second thing that you have to have as far as a branch office is concerned, because the main office, the broker of record, is going to be the broker that is supervising the daily happenings at that office. Any branch office in the state of New Jersey needs to have someone identified as a broker manager, okay, who is supervising the staff at that location. Now, their name is not going to be on the front door, okay, because again, it has to be the broker of record, but there has to be one broker salesperson working at every office designated as the office manager, okay? So that is a must. The next thing that we'll talk about is that a broker can have, in the state of New Jersey, an office in their residence. They can have an office in their residence, okay? However, needs to be separate entrances for the public and to the residents, okay? Also, they have to have separate spaces within the house, okay? And it can never be in a salesperson or a broker salesperson's home. So a office or a branch office can be in the home of the broker of record. It cannot be in the home of a salesperson or a broker salesperson. So we were just talking about this, the trust or escrow account. So we kind of dived into it a little bit when they mentioned it first up front when we were talking about it like 2 slides ago. But now we're going to talk a little more, okay? And we're going to talk about a couple of compliance issues that we have as salespersons, brokers, and broker salespersons that we need to talk about. So the first thing is that the trust or escrow account is really used for the deposit of money belonging to clients, okay, that we're working on behalf of. And what happens is a lot of times what has been tradition is that there's usually a $1,000 earnest money deposit, or they would call it a good faith deposit, that was given at the time of an offer being written. So a buyer would write an offer. The realtor would take $1,000 check and deposit it into this trust escrow account, non-interest bearing. Keep that in mind, okay? It will be the company's trust escrow account. Now, they must deposit this within 5 business days, okay? So if you come into contact with the check and you say, I will deposit this into our trust escrow account, that must be done within 5 business days, okay? You also must make sure that it is not going into an expense account or an account used for operating expenses. Anytime that there is a mixing of funds, okay, that is considered commingling. Commingling is an illegal practice in New Jersey, okay? A legal practice in New Jersey to commingle your escrow account with your operating expenses, okay? Now, documents, okay? I always like talking about documents because, people always have questions. As far as the practicality and the legality of real estate, regulations regarding documents and sales contracts and offers and things like that, this is something that I'm asked on a daily basis. So this is something that I always like to discuss, and I always like to stress that this is something that is very, very practical too. So let's talk about what kind of documents you need to keep at the office as a broker of record, as a salesperson to be compliant. It's what I refer to as the rule of 6. What is the rule of 6? Let me explain. The rule of 6 says that any unaccepted offers you must keep for 6 months. Any accepted offers, executed contracts, leases, things of that nature that are executed, completed, done, must be kept for 6 years. So it's either 6 months on unaccepted offers, unaccepted leases, 6 years for executed, accepted, and completed. All right. Also, licensees can prepare sales contracts for 1 to 4 family units or single vacant lots. Okay. Now, we'll talk more about attorney review and opinion 26 later on, but I'm going to give you kind of the 10,000 foot view. So let me talk a little bit about this. Back in the day in a kingdom very, very far away, the New Jersey Bar Association had a complaint filed against the New Jersey Realtors saying that realtors should not be allowed to prepare sales contracts. Why should they not be allowed to prepare sales contracts? That's a great question. They felt that they were not attorneys and that they should not be giving legal advice. The court system agreed with that statement, that realtors were not attorneys, but did not feel that for 1 to 4 family homes and single building vacant lots, that realtors could not fill in a pre-filled contract, okay? Basically a fill-in-the-blanks contract. So now what happens is this. We fill in a 1 to 4 family home or single vacant lots. We prepare a regular pre-filled contract. Some companies require that you have their contract. Others just say, yeah, the New Jersey Association of Realtors contract is sufficient. So what happens is this. You fill that out, and then on the cover page of every offer is opinion 26. Opinion 26, basically, I'll give you the overview, says this. In the state of New Jersey, a realtor is not an attorney. You have the right as a client to obtain legal counsel or not obtain legal counsel. That is totally on you. Now, if you choose to get legal counsel, what happens is legal counsel will reach out to the other party's legal counsel, and they will discuss attorney review. Attorney review happens immediately upon the signatures of all parties, so buyer and seller, and tenant and landlord, because this applies also in leases as well. Okay, and what happens is this: the pre-filled contract then is not legal and binding because the attorneys have the right to review it, discuss it, and they have the right to make any changes that they both agree to. Once they both agree to it, what will happen is the contract will then be considered legal and binding with all the necessary changes that they have made. Once it is legal and binding, other than contingencies that are set forth in the contract, everyone is bound to act on that contract, or otherwise it will be found in breach of that contract. Now, if you opt to not have an attorney, that is absolutely fine. Again, a realtor cannot give you legal advice, and that's something that I think is prudent advice for anyone who's listening to this. You do not want to have someone say, hey, can you give me legal advice? No, there's some things also that you should just kind of step back from. If there's a question that seems a little too complicated, even if you might know the answer, something that you might want to do is say, this is really a question that should be geared towards legal counsel, and if you have not considered getting legal counsel as of yet, this might be a prudent time to do so. And that's always a good practice. So if they choose not to have an attorney, the contract will be legal and binding within 3 days of everyone signing it. Okay. 3 business days. We don't count calendar days because attorneys don't work on holidays, things like that. Okay. Also, all offers that are in writing must be presented to the seller within 24 hours. Okay. This is a must. Everyone always asks me, how long do people have to present the offer? Presenting the offer is usually not the issue. Usually it's presented to the seller within 24 hours. It's the response time as far as the seller getting back to the buyers. There is no law regulation with that. So Godspeed with certain clients and certain issues that you might have. However, the law basically states that it must be presented within 24 hours. After that, it really is, no regulation. They don't even need to respond to it. They just need to know that it has been presented, acknowledged, and received, okay? So this is going back to the copies of all unaccepted offers purchased of 6 months. This is the rule of 6. They're basically talking about all of the records 6 years. If you go by what I said in the other slide, it's exactly that. The rule of 6 months for unaccepted offers. And also this is basically saying too that copies of contracts of sales and listing agreements must be kept for 6 years. Again, going back to the rule 6, okay? Written agreements must include compensation and broker. Here we go. This is an interesting one. Remember I was talking about the employment contracts. Talking about employment contracts, here's what we're looking at here. This is the contract between a broker and a broker salesperson or a salesperson. Okay, so the broker of record and the salesperson or broker salesperson have to have an agreement, okay, a written agreement. They must outline the compensation to be paid, and also there must include a broker promise to turn over monies due to the salesperson or broker salesperson within 10 days after a commission is received or as soon as the check has cleared, okay? So it needs to be known that you can't have your broker waiting to pay you, okay? So you have a 10-day right to have the money, okay? You have that right by law. By operation of law, you have that right to require that of your broker, okay? Also, must talk about any of the business that you are going to leave behind. So it's going to talk about the rate of compensation after the salesperson leaves the broker's firm. So there's an exit strategy. There has to be an exit strategy in your employment contract so that they know what is going to happen with the business that you're leaving behind, okay? Because you'll see in Chapter 3 where the agency relationship is as far as that is concerned. So we'll talk about that in Chapter 3. That's a good chapter. Advertising. Oh, love advertising. So let's talk about this a little bit. Advertising. Now, if you are advertising in the state of New Jersey, you must advertise under your legal name. You must advertise under your legal name. If you have a nickname, you are more than welcome to use the nickname, but you must use the nickname in parentheses between your first and last name. So if you are, Barbara Babs, whatever, then you would have to write in your advertising, Barbara Babs, Simonson, like myself, Stewart. So my legal name is Stewart J. Jacobson. I use my middle initial. So in my advertising, I'm going to have Stewart J. Jacobson. Now, if I preferred people to call me Stu, I would have to write my advertising as such. Stewart, quotations, Stu J. Jacobson. And I would also have to include in my advertising, this is for any advertising whatsoever, you must include your brokerage name, and it must be larger than your name, okay? So, and it doesn't say how much larger. It just needs to be larger. So some people go really kind of dicey with that, where it's like a 1-point font difference, but it's larger. You can keep that in mind that the Real Estate Commission is looking at that because it's intended to let the public know exactly who they're dealing with, like, so that there's no mincing of words. Because right now there's a lot of teams, there's a lot of groups, the Diamond Home Selling Group, the whatever group. Yeah. There's a ton of them out there. And what happens is and then they usually work for a Keller Williams, a Remax, a Century 21, things like that. So what'll happen is you'll see several things on there. You'll see Sally Smith, Diamond Home Group, and then Keller Williams. That's confusing. They really want to make sure. So the Real Estate Commission is a consumer advocacy group. Okay, they are a consumer advocacy group. They're going to want to make sure that the general public can look at an advertisement and say, I know who I'm dealing with. This is so-and-so who works at blah, blah, blah. Okay? So those are the things you really want to know, okay? And going back to that, because we're talking a little bit about the groups, teams, things like that, I found on the test as of recently, so I'm recording this in the third quarter of 2018. As of recently, there has been a real big shift for the Real Estate Commission to start asking questions on the test that have to do with unlicensed assistants, and what you could do as an unlicensed admin with a real estate company, and what things you can't do. So that's something that I think is a good thing for you to refresh on if you haven't done so already. Okay. Now, here's another couple things. The commission rebates. Commission rebates are a new thing. Commission rebates came in about 2009. Please don't quote me on that, though. You won't need to know that. That's really kind of just a miscellaneous Final Jeopardy question trivia. So commission rebates are this. They're basically when a real estate company decides to rebate back a portion of the buyer agent commission. Now, all commissions in the state of New Jersey are negotiable. We need to make sure that we're saying that a couple times, because you want to kind of bash that into your head. All commissions in the state of New Jersey are negotiable. Commission rebates may only be paid to the buyer that is on the seller's disclosure, the closing disclosure. Okay, so the buyer who's named on the closing disclosure is the only one who can receive a commission rebate. Now, depending on certain circumstances with lenders, things like that, closings, etc., the commission could be as a credit at closing or received as a check afterwards, as long as it is paid to the buyer of real estate, the buyer on the closing disclosures. This can only be paid by the broker, and it cannot be dependent on a lottery contest for game. So this could be something that some brokerages just say, hey, work with us and we'll give you a commission rebate of $500 at closing. That's totally fine. It's not dependent on a lottery contest or game. As long as it's not, it's fine to tie the rebate to working with them. So that's a totally fine practice. And it could be, there is no minimum, there is no maximum. So it depends on what you want to do. Then you can tie it to a business strategy. Okay, sell your home with us and we'll give you our full commission on the buy side. Yeah, okay, you could do that. You know, it's a business practice and something that you have to keep in mind too. And we'll go into a little bit of the ethics of real estate. A little bit about the ethics of real estate is this. You want to make sure that you are not bashing any third-party companies who might have something like this as a business practice. You don't want to be doing that, okay? So there's going to be a lot of different business practices, but what you want to do is you want to make sure that you're going through and you're helping yourself along and you understand what this is and that this cannot be paid to anybody but a buyer, okay? This is a buyer rebate, okay? Seller rebates don't exist because sellers would just get a reduced commission on the home. You can negotiate that. You can negotiate a reduced commission. You don't get a rebate. You don't pay 2% and then get a rebate at the end. There are rebates to sellers are illegal, okay? Now we're going to talk a little more about commissions, okay? Since we were just talking kind of a little bit about talking about other brokerages and how there is an ethics violation with the National Association of Realtors and local realtor boards if you do bash any third-party business. There's also a law in regards to colluding with another brokerage, okay, or multiple brokerages to try to even remotely resemble something that would establish standard commission rates. There are no such thing as standard commission rates. There are no such thing as standard commission rates. Customary commission rates is another word that I've seen people throw around. There is no such thing as customary, standard, or anything like that. Every commission in the state of New Jersey is negotiable. You need to know that and understand it. What they usually tie to price fixing, illegal price fixing, is they'll refer to the Sherman Antitrust Act. Based on the Sherman Antitrust Act, any collusion between brokerages, salespersons, anybody who is a licensed real estate professional to establish some sort of customary, traditional, or standard regarding commission rates will be seen to be in violation of the Sherman Antitrust Act and price fixing. That's Chapter 2.